Good afternoon. My name is Deb Van Dyke Reese, and I'm the director of the Nebraska Court Improvement Project. And it is my pleasure to welcome you all to today's CIP webinar focused on the Central Registry. And so prior to us getting started with the content and having Sheila present on the Central Registry, I wanted to cover a few housekeeping items. The first is that this webinar is being recorded and will be available for review on the CIP YouTube channel following the presentation. And if you are an attorney who will be requesting CLEs, this webinar has been approved for CLE credit, and we will share the CLE number at the end of the presentation. We do have some time reserved for questions following the presentation, and you can use the Q&A tab to register your questions. And if you haven't done so already, if you can make sure that your microphone is muted, that would be great. Prior to turning it over to Sheila, I wanted to bring your attention to a couple of upcoming CIP events. The first is another webinar, which is on the intersection of brain injury and juvenile justice, which will be presented on July 27th at noon. We have our Project Embrace lecture series, which is happening the first 2 weeks in August in multiple locations across the state. And registration for the Project Embrace lecture series will be open until July 21st. And then we have our regional conference, which will be focused on restorative justice on September 8th and 15th in 2 different locations, and registration for that has just opened. All registration and information can be found on the CIP website under the News and Events tab. So it's my pleasure to introduce Sheila Trejo, who is the Program Specialist Supervisor of the Central Registry. And she has been with DHHS for 8 years. Previously, Sheila was an initial assessment caseworker and supervisor, and we really appreciate Sheila coming here today and sharing information and maybe answering some questions about the Central Registry. So I will go ahead and turn it over to Sheila. Thank you.
Thank you. Okay, let me go ahead and share my screen here. All right. So today I'm going to be talking about the Central Registry, and the first slide here talks about kind of what I'm going to be going over today, and then go over some and have some time for some questions at the end. And so we'll just go over the Central Registry, what it is, and then findings, and then the minors on the Central Registry, expungement appeal hearings, and the Central Registry background checks. So first off, what is the Central Registry? The Central Registry is a confidential database that's kept by every state according to federal law. It includes all agency-substantiated and court-substantiated allegations of abuse and neglect of children and vulnerable adults. The Central Registry reports are typically used to aid agencies in the investigation, treatment, and prevention of child abuse cases. The records are used to screen people that are entrusted with the care of children and vulnerable adults. So people have their background checks done on the Central Registry for when they are applying for jobs or volunteering for being a coach, anything that has to do with caring for children or youth or vulnerable adults. So there are 2 different findings on the Central Registry. One is court substantiated and the other is agency substantiated. We will get into them a little bit further into detail. This slide I put in here just to kind of go over or just to have the statutes in here for references. There's the statute 28-71201 and 28-713, which reports of child abuse and neglect and duties. There's the 28-351 to 371, which has the definitions for APS, 28-720 for the central registry classification, and 28-376 for the APS registry classification. I'm not going to get too deep into this slide because, like I said, we will get into each of them separately in a little bit. So the central registry entry decision is based on two components. And the first component is, does the incident meet the statute definition of child neglect or abuse? So that means for maltreatment, does that mean that they knowingly, intentionally, or negligently caused the child to be placed in a situation that endangered his or her life or physical or mental health, cruelly confined or cruelly punished, deprived them of necessary food, clothing, shelter, or care, if they were left unattended in a vehicle, if they are 6 or younger, place them in a situation to be sexually abused, exploited, or sex trafficked. The other component is for the APS side of things. So there is abuse, cruel punishment, exploitation, and neglect on the APS side. Plus, they also have to be identified as vulnerable. So that means they're 18 years or older and they have a substantial mental or functional impairment for where they have a guardian or a conservator that's been appointed under probate code. So the second component with the central registry decision is there enough evidence that it occurred? And so with the central registry evidence, it is the preponderance of evidence more likely to have occurred than not. So we only need 51% of evidence that it occurred. Than not. Evidence that supports the central registry entry will include what happened, so what abuse or neglect occurred, and are the allegations correct? So sometimes when we get reports, it will have an allegation of something that occurred like neglect, where the allegation should be abuse. And so we have to make sure that the allegations are correct. And then did it meet the statute definition of abuse or neglect, which we talked about previously. And then we also have to have what evidence that we have that supports the findings. So that can include doctors or therapists reports, law enforcement reports, statements made. That's where we get most of our evidence is our interviews with children, mainly the victims, perpetrators, anybody in the family, parents, schools, counselors. We can also have physical evidence, pictures, and then we can also have court documents as evidence. There's forensic interviews when children go to the CAC to be interviewed. And then we do take into account the evidence that we get from other agencies. However, it is ultimately the department's decision regarding the findings of placing somebody on the central registry. Now on the second one, with the statute definition of abuse or neglect, the department uses the SDM, the structured decision-making assessments, to decide whether it meets the threshold of abuse or neglect. The facts of the case can be outlined, what the safety decision is and why. The safety decision doesn't necessarily mean that will be the finding. A child can be safe in the home, but the finding can be substantiated, and vice versa. So the child may not be safe in the home and the finding could be unfounded. So safety does not equal finding. When the perpetrator is cited by law enforcement, for example, when a child is found in the car when they are 6 or younger, and law enforcement writes them a ticket, and it is pending in court, then they will be court pending as a finding. Or if their children are removed from their care and they're not yet adjudicated, then they will be court pending. When they are court pending, they are not placed on the central registry. So this happens with any criminal complaint or for a 3A juvenile court case. So now we're going to get into the difference between the court substantiated and the agency substantiated findings. So a court substantiated finding is when an individual has a juvenile court case that's a 3A, and the petition is a fault case and the children are adjudicated. So that would be court substantiated. So if the perpetrator is an adult or a minor and they have a child that is adjudicated in a 3A fault case, they will be court substantiated. If the perpetrator is found guilty in a criminal court for a charge directly related to abuse or neglect, then they will be court substantiated. So this is true for both an adult or a minor. So if they are found guilty in an adult criminal court, not juvenile court, then they will be court substantiated. It has to be directly related to abuse or neglect of a child. Agency substantiated, the department has to have a preponderance of the evidence to support the entry. So if the county attorney dismisses the juvenile petition or dismisses the criminal case, and the department has enough evidence to say that this happened, the department can still place them on the central registry. If the judge says, no, there's not enough evidence that dismisses the case on his own ruling, his or her own ruling, the department does have to unfound the allegations. If a minor is charged in juvenile court, in a 3B, for example, that cannot be court substantiated. That would be an agency substantiated. And if the perpetrator is charged with a criminal offense that is a child abuse related offense, and they plead it down to disturbing the peace, then it could be changed to, or it could be agency substantiated, since it is no longer directly related to child abuse or neglect. Now, the department does have to have a preponderance of the evidence to support the entry. This is also true if law enforcement or the county attorney decides, I'm not going to proceed with any legal action, and the department feels that there is enough evidence saying that this did happen, then we can place them on as agency substantiated as well.
Sheila, before you move on, there was a question that stated that the documents and information that DHHS uses to place on the registry, is the individual allowed an opportunity to view any of the information?
Like the evidence, so the reports that are gathered, so like the medical reports.
I believe that, I think that the question is that the information that DHHS uses to determine whether somebody needs to be placed on the central registry, can the person that might potentially be placed on the registry have an opportunity to view that information prior to maybe them being placed on the central registry?
Prior to being placed on the registry, that's a good question that I guess that would be circumstantial, I would say. I think it depends on the documentation and what it is, and where it's coming from or who it's coming from. That would be hard to answer. I mean, because we're going to get into like expungements and appeals, and after being placed on the registry later on, and they would definitely get to see all those documents. So, I mean, I'm not sure on that answer.
Okay, thank you. And there was also another question about how there is notice for somebody. Is there notice provided to somebody if they are placed on the central registry?
And we will get into that in just a little bit. So we'll save that for later.
Those are all the questions right now.
Okay, all right. So next one is minors. We're going to talk a little bit more about minors on the central registry. So minors are age 11 and under cannot be placed on the registry. So the only minors that can be placed on the registry are 12 to 18. They cannot have a status of court pending at any time. And they are allowed, if they are placed on the registry, they are allowed 2 mandatory expungement hearings. So the first one is within 60 days after they are initially placed on the registry. And the second one is within 60 days of their 19th birthday. So they are automatically given a hearing when they're put on and when they turn 19, just for the department to look over and see, first of all, whether or not the entry is valid onto the registry. And secondly, to see if they have done anything to rehabilitate or have done anything to be at a lower risk to reoffend. So that's something with the minors that's different than with an adult on the central registry. So expungements, we'll talk a little bit about expungements. So expungements is where a person requests that their name be removed off of the central registry. And someone can request this at any time and as many times as they want to. The request forms can be found online on our public website. And with the request form, we just request that they also provide any information that supports their expungement, such as character references, certificates of class completion, therapy notes, anything that shows that of good cause. Because when we look at expunging them off of the registry, we look at several different things. So a few of the things are listed. We look at how long they've been on the central registry. We look at the seriousness of the incident. So someone who has been placed on the registry for leaving their child, their 5-year-old in the car while they walked into the gas station, we're going to look at different than, something like a broken bone for physical abuse. And then we also look at the accuracy, if the person being placed on if the reason is valid. And then we also look at what they've done to correct the issue. So that's good cause. So I have some examples listed. So if they were a minor at the time and they were placed on probation, did they complete their probation through their juvenile court case? If they were recommended therapy, did they complete therapy? Have they had any intakes since their case with us? Have they had any other criminal charges? If the reason that they came, if they were on the registry was because of drug abuse, have they had any, treatment or any, have they had any criminal charges related to drugs since then? So any evidence that shows that the conditions contributing to the entry has changed, we just want to see that they are at a lower risk at reoffending, and that what they have done that led to their name on the registry, that they're at a lower risk for that. So if somebody requests an expungement and it's denied, they have a right to appeal the expungement denial. So when they appeal the expungement, the program specialist will prepare the exhibits and will work with the hearing office to schedule the hearing. And the notice will be sent to the appellant, and the appellant's not required to have an attorney. However, if they wish to have an attorney, the central office staff, the program specialist, may arrange for HHS legal to have the HHS attorney present as well, if they feel it's necessary. And during the hearing is telephonic, and the program specialist presents to the hearing office why the appellant's on the registry, and why they feel that the entry should not be amended or changed. And then the appellant has the opportunity to say why they feel that the finding is not valid, or that they feel that they have good cause to be expunged. And then after the hearing office makes a final decision. They can either affirm the decision or reverse what the department has found. And a director over CFS will review the recommendation by the hearing office and sign off on it if they agree. And if the appellant does not agree with the decision, they can appeal that in the Lancaster County Court of Appeals, which is their last option for appeal. So central registry background checks. When people have background checks ran for jobs, volunteering, anything where they would be dealing with children or vulnerable adults, they need a central registry check completed. So the central registry background checks are completed by a central office. Any open investigations, any court pending findings, anything where there is anything where there's no findings on there, it's going to show up as no record found. It's not going to show up on the central registry check. And on this slideshow, there is just a tie to the portal, because you can go on there and do a self-check on the portal's website. You can also do a mail-in as well for the background checks. There are other case status determinations besides the court pending, court substantiated, agency substantiated. There is unable to locate, which is where the department goes out to investigate. They make good faith efforts to go locate the family. However, they're unsuccessful in locating them, no matter how hard they try, and they cannot find them. There is unfounded, where they go out, they meet with the family. There are some concerns, but it does not meet the statute of abuse or neglect, so it's unfounded. Or they go out and what was reported, it's not true, so it's unfounded. There is also alternative response, where there is not allegations of abuse or neglect. It's an alternative approach to working with the family, where we go out and help them. And instead of placing them on the central registry, that's why there's no allegations in the alternative response program. And then the other case status determination is law enforcement refused to investigate. And that is on our law enforcement only intakes, where the department does not investigate those, only law enforcement does. And those are where law enforcement does not go out and investigate those. So all of these case status determinations would not show up on a central registry check as well. So the notice to perpetrator. So a letter is sent to the perpetrator whenever any of these 4 findings are put on. So unfounded, court pending, court substantiated, or agency substantiated. So when an entry is put on as court pending, a letter is sent to the perpetrator, and when it's changed later on to court substantiated or to agency substantiated, or later on when it's changed to unfounded, another letter is sent when that is changed. So just kind of wrapping up and going over what we went over today. So in order for somebody to be placed on the central registry, we have to have a preponderance of the evidence, and it must meet the statute of definition, that must meet the statute definition of abuse or neglect. And only court substantiated and agency substantiated entries place somebody on the central registry. Court pending does not place someone on the central registry. Minors 12 to 18 cannot be court pending. Minors 11 and under are not placed on the central registry, and anyone can request an expungement at any time once they've been placed on the central registry. And minors between 12 and 18 have mandatory expungement hearings, one when they are placed on and one when they turn 19. My contact information if you have any questions. And then we have plenty of time for questions that I will try to answer the best I can.
And there's a number of questions in the chat or in the Q&A, but I could maybe kind of summarize them. So there was a lot of questions about the appeals process and the Lancaster and having the appeals in Lancaster County. Number one, so does it always have to be in Lancaster County? And what court is it that somebody would be appealing to in Lancaster County? Is it the Lancaster County District Court? Is it the Nebraska Court of Appeals? What is the court in Lancaster County that someone would be appealing to?
So I'll have to get the exact details, but from what I was told, it was the Lancaster County Court of Appeals. And I believe that is because the main office is there.
And then there was also a clarifying question about that the appellant has to hire an attorney of their own if they wish to, but it's at their own expense. Is that correct?
Yes, that is correct. They can have an attorney if they would like, but that is at their own expense.
And then who is the hearing officer, or who are the hearing officers?
The hearing officers are they are through the department. They are out of Lincoln. There's several. I do not know all of their names. I do not work with them. Morgan Schulte is the expungement and appeal worker. So I do not work with them. So I do not know all their names.
And then there was another clarifying question about even after somebody is on the registry, do individuals have an opportunity to review what is being alleged against them? Or do they ever get a chance to kind of see that information that is being alleged against them once they are on the central registry?
Yes. So if they do an expungement and they appeal the denial of expungement, they'll get the exhibits. And that's what we use to determine. So that's going to have what we look at that has all the information that we use to determine why they're on the registry and why they should be on the registry.
Okay. And then another question is placement on the central registry to be permanent, absent a request for expungement? Or are there any automatic reviews after a certain number of years where someone may be taken off the central registry?
It is permanent. So you remain on the central registry forever unless you request an expungement, unless it's a minor. So minors are the only ones that can get automatic hearings. They are notified that they have a hearing within the first 60 days when it's scheduled, and when they're 19, they get notified of the hearing as well.
There was a question about expunging a felony background. How long does that take and what's the process?
I think that's different than the central registry. The central registry is completely separate than criminal. So that would be different. Oh, Susan's on. And she has an answer right there. District Court of Lancaster County.
Okay, thank you. Let's see.
The District Court of Lancaster County.
So another question was, the alternative response finding is not the same as those voluntary cases where there were allegations of abuse and neglect. Is that correct? And then the second part of that is it standard practice to enter those voluntary case situations as unfounded instead of agency substantiated?
So alternative response does not have findings. The finding for alternative response is actually alternative response. There's no way to put a finding in. There's technically no allegations on that type of intake. It was created to be a way to prevent abuse and neglect. People call in with some concerns that are typically seen as people that generally need things like help with monetary items, whether it's like food or maybe they need help with cleaning, things that aren't, it started out not as major, like with drug use or things of that nature. And that's why there weren't the allegations. And so you can't even add a finding on those. Now with the voluntary is different. There are findings on voluntary. Alternative response is voluntary. I think that it just depends on what kind of intake you receive, because alternative response is also voluntary. If you get a regular intake and the family decides, hey, I wanna work with the department to get help, and it's voluntary, as far as the finding with working voluntary services, I think that's separate from them working if the incident met the statute of if there was a preponderance of evidence and it met the definition of abuse or neglect, then I think they could substantiate it, whether they worked voluntarily or not. I think that's up to each worker. I think that's each individual circumstance on its own. It's a very, that's also a circumstantial, each case by case basis. So I couldn't say overall on that answer.
Okay. A couple of other questions that are somewhat related. So again, talking about agency substantiated cases, who makes the decision, who presents the evidence to that person, and I think you've answered this already, but is the person who the evidence is being presented against given an opportunity to be heard prior to the decision by the agency to substantiate or not?
So the finding is decided by the worker and the worker supervisor. So whoever the worker goes out and does the investigation, they're going to go out and they're going to talk to the family. They're going to find out what's going on. They should be having these conversations with the perpetrator and talking about what's going on. They should be knowing what's going on prior to being put on the registry. Unless it's something that they're not able to be found. I'm not sure. But they should have an idea of what's going on.
There were a couple of questions about that notice that is provided to I believe youth between 12 and 18, something like that. The notice 60 days after being put on the central registry, and then 60 days after their 19th birthday, just about how is DHHS able to keep current on the best way to contact that young person, their current address? There were a couple of questions about that.
So we do look at our system. If we looked at their last known address that we have, we also have access to other systems that we can look into to see their address for like any kind of, if they had any other like criminal cases or juvenile cases. We do have access to like INDEN to look to see if their address changed or anything like that. So we do have access to other places to see if their address has changed. If we send out a notice and we get it back, then we know we don't have the correct address. And we try to find a different one. But I don't know how often that happens.
Okay. I'm sorry, Shayla, I cut you
That's
off.
okay. Usually we're pretty good because people update it on the system because it does tie in. We do have like all of the economic assistance tied into our system as well. So people update their address for the economic assistance piece because we do still have them on there. We get the notification prior to them turning 19. So we still have them in the system. And so normally we have their updated address.
And there were a couple of other questions about the hearing officer. Does each case have one hearing officer or person that makes the final decision, or are there multiple hearing officers assigned to each case? And then also, if you know the qualifications of a hearing officer.
I do not know the qualifications. I don't know that one. But there is one hearing officer per case. And there are multiple hearing officers. So when I have filled in for Morgan, I've worked with different hearing officers on different cases. So, but I do not know their requirements or qualifications.
Okay. And it looks like we have answered most of the questions, unless there are other questions that people want to add. I think that's slowing down. So I guess there was one other question about having the slides available for people to reference. And
Yeah,
so
yeah, I can send those.
wonderful. So we'll make sure that we have those available too. And as a reminder, this webinar has been recorded. It will be on the CIP website, and the activity number, the MCLE activity number, has been placed in the chat for those of you who are attorneys. And I want to thank you all. First of all, thank you, Shayla, for presenting this information. And thank you all for joining us today for the CIP webinar on the Central Registry. So thanks so much, and have a great day.